Matthew, are you ready? Okay. Good afternoon and welcome to the Senate Judiciary Executive Session of March 12th, 2024. We have a bill signing this afternoon at 1:15. So what I'm going to do is I'm going to put the committee into recess until 20 minutes of 2. We're in recess, so. Yeah. Oh. You ready, Matthew? The committee will come out of recess, and can I get a motion to go into executive session?
So moved.
Moved by Senator Whitley, seconded by Senator Gannon. Okay, all in favor say aye.
Aye.
Any opposed? Okay, I'm just gonna read you, the bills that we are not taking up today. So if you are here for one of those bills, it's always a good thing to know. Senate Bill 304, Senate Bill 461, Senate Bill 562, Senate Bill 413, Senate Bill 422, Senate Bill 426, Senate Bill 463, and Senate Bill 459. We're not going to take those up today. We could take them up on Thursday, depending, some of them up on Thursday, depending on amendments, and people are still talking about these, so. Okay, so we are going to start the session with Senate Bill 358. I'd like to move on to pass.
Second.
Seconded by Senator Gannon. Senator Gannon, do you want to talk a little bit about this?
Do in about 10 seconds.
Okay.
I picked up earlier this year when I was in Philadelphia that they were giving out-of-state driver's licenses. Illegal aliens were getting driver's licenses, which bothered me because I know in
You gotta put your,
I know in Pennsylvania that once you get a driver's license, you're automatically also registered to vote. But besides that, we have people coming here who shouldn't be on our roads, and I don't want people who shouldn't be in the country driving in New Hampshire's roads and endangering our public. So that's part of the reason I brought the bill forward.
okay. Senator Whitley.
Yes, so, well, one, I have to take some umbrage with the use of the term illegal alien. That's not a term that is grounded in an individual's humanity. So an individual who is undocumented is a more humane way to refer to these folks. What I hear from the bill sponsor about the need for this bill, it has to do with curtailing immigration or curtailing immigration by those who are undocumented, but this bill does not do that. I think all it does is undermines, this central principle we have of reciprocity between different states, these various interstate compacts we have. So to not recognize a license that's issued by another state violates those principles and perhaps is quite illegal. And I just think the bill is punitive and it doesn't really do much. So I'm not really understanding the problem that we were trying to solve here.
Okay. Are there any further comments? Senator Abbas?
Thank you, Madam Chair. I understand the term that my colleague from District 23 used, that some find offensive. That's just a legal operative term. So it's really hard to fault someone for using it. And I think if anyone has a problem with that term, they should contact the federal delegation about perhaps changing at the federal level, which I have no problem changing the term. But if that's the legal operative term, I think it's appropriate to use it, especially in a legal setting like we're in. With that being said, in respect to the,
Oops, sorry. Oh.
just in respect to the,
Mike. Apologize, everyone. Sorry.
no, it's not a problem. In respect to the amendment, this applies when the class of license that's issued is issued exclusively only to illegal immigrants. Am I reading that correctly?
Yes, in other states, in our state right now, if you're an illegal alien, or whatever term you choose to use, they're not entitled to a New Hampshire driver's license. If you come legally, you're a student studying here, you can get a driver's license. If you're here on a J-1 visa, you can get a license. But people who have entered the country illegally are not entitled in New Hampshire to get a license. That being said, other states are offering, I believe we don't have reciprocity with Massachusetts, by the way, but the states that we do have reciprocal provisions with some of them are allowing people who have broken into the country to get licenses, which is going to lead to a shortage. Then they're going to be applying, like in Pennsylvania, they can now register to vote. And so in these other states that are giving voting privileges, housing privileges, we're in a housing shortage. If we have more people who shouldn't be here or who have come here and they're hiding under the woodwork in plain sight, we just want them to be, if you came here legally, you can get a driver's license. If you come here illegally, you're bringing in a whole magnet of problems with illegal aliens that we're not ready to handle in New Hampshire.
Senator
Thank you.
Whitley?
So I just want to make another comment. Again, I think we have an obligation to use terms that recognize people's humanities. The administration has actually issued many memos, including from the top official at Customs and Border Protection, that we should not be using that term. So the federal government is already telling us that, and I think we should follow that. In terms of the amendment does
There's no
not.
amendment. We're
Oh,
not
he
ready.
just spoke to the amendment.
I didn't mean to, I'm sorry, I'm just talking
there is
about
no-
the bill
Senator
itself.
Abbott just spoke to the
There
amendment.
is no amendment.
There is
It's just the- No, nope.
I have one in front
Just
of me. I
the
was looking.
bill as.
No, we haven't
the bill is-
introduced it.
Yeah, there is, then we won't be introducing the amendment, so. Okay, are you all set?
We need to backtrack.
Okay. The only thing that I would say, I had some research done on this because, it is a very important issue, and it's interesting to see that every state does something different. In some places, it's prominently displayed that it's a driver privilege only. In some places, they don't even have anything at all. And I'd just like to, my colleague had brought up the state of Massachusetts. They had passed a law in 2023 to allow illegal immigrants to get only a standard driver's license. But the problem is they haven't changed what a standard driver's license card looks like. And it's indistinguishable between a citizen with a Massachusetts standard driver's license and an illegal immigrant with the same type of license. We know that we all use our licenses. They're really basically used to establish our identity. Many places that we go, they'll ask to see your driver's license. And that includes voting. And our voting law allows individuals who are coming from other states that just moved to New Hampshire, and if they have a driver's license from another state, to be able to vote initially with that driver's license. I think we are really trying to be very cautious here and protect our electoral process. And for that reason, I'm going to be supporting the bill. Senator Whitley?
Sorry, I do have to say one additional thing about voting. I think it's very clear that you cannot vote if you are not a citizen. And so I think we need to separate those issues. You still need to prove to vote that you are a citizen, right? And so I think we do need to separate that issue.
Senator Abbott?
Thank you, Madam Chair. I believe that when someone registers to vote, if that person shows a driver's license, that's all that it's needed, and that's always the concern that I have. Is that's all it takes. Is it illegal under our election laws for an illegal immigrant to vote in a New Hampshire election? Yes, but I think the person working at or volunteering at the election polls, they're not going to be asking people to verify the citizenship on the spot. A driver's license is all they need to show to be registered. Even if it's not a state license, there's some things that they can, affidavits they sign, that's all it takes. So for that reason, I would be supporting the.
Okay, is there any further discussion? Senator Gannon?
I'd just like to back up Senator Abbott, what he did say. I did at the presidential election ask in Sandown if I had a Massachusetts license, and I said I live on 15 Main Street, would they let me vote? And they said they would let me vote that day. So there is no one really checking to see if you are a citizen of the United States.
Okay, is there any further discussion or debate? Okay, seeing none, we have a motion of ought to pass. All in favor say aye. Aye. Any opposed?
No.
Okay, Senator Gannon?
Sure.
You want to do this one? Okay, next we have Senate Bill 417. I'd like to make the motion of ought to pass.
Second?
And it's okay, seconded. And I know Senator Whitley has an amendment. Do you want to discuss your amendment?
Yes, thank you so much, Madam Chair. I appreciate the committee's patience with this bill. This is a very, very important topic, as we heard in the hearing. And I want to commend the Office of Child Advocate and the Department of Health and Human Services, who have really, I wouldn't say battled it out, but have hashed it out, have gotten, and we spent hours upon hours to get this bill to a place that they can both support and protect child safety. So, Madam Chair, I'm wondering, I will move Amendment 1063, and if you would, thank you. And if you would allow Krista from DHHS and Alyssa from OCA just to go through the amendment, because it is
Okay.
contains some substantial changes.
Sure, if you'd like to come forward.
Thank you.
Good afternoon.
Good
Lisa
afternoon.
Massio, I'm the Associate Child Advocate for the state of New Hampshire, and we have worked tirelessly, I would say, with Senator Whitley, DHHS, as well as the JRPG, the Juvenile Reform Policy Group, on this language. So just to run through it quickly, the first two sections are identical, amending identical sections of the bill. That was really just some word cleanup to make it more in line with the rest of this bill, as well as some of the companion bills here in this committee as well. Just adding language about the types of placements, that they're certified for by the Department for Care of Children under 169C and other state-operated treatment programs. Adding a new internal reference in 2A there, as well as including the terminology a family setting rather than just to the community. We are looking to have children in homes. And then section B there, which is identical in both of those parts, just fleshes out a little bit more and also aligns it with sort of current federal policy that's being used in this arena in the courts. That the court does have to determine first that the needs of the child cannot be made in a home, fictive kin or foster family, and that the shortage or lack of those foster family homes or resources is not an acceptable reason for placing a child in an institutional setting. The other two sections, so basically starting at the top of page 2, those are pieces brought over from HB 1573, which is a bill currently in House Finance. Prime sponsor is Representative Pearson out of the Child and Family Law Committee. We at the OCA and in conversations with DHHS felt that those two sections fit the themes in Senator Whitley's bill and sort of made it more complete to have all of those pieces in one place. So the new section 169F7 at the top of page 2 there is identical to what is currently in an amendment for HB 1573. That's really just sort of making clearer the requirements of the DCYF workers, the people specifically assigned to a child, in the monthly visits that they already do. So workers are already visiting all of the children every month. This just lines it out a little bit more clearly of what information they need to be gathering in statute, as well as creating a new form. So that's aimed at the DCYF workers. The next section, which is the final 2 pages of the bill, adds a new 169F8. The substance of Senator Whitley's SB 417 already made reference several times to increased judicial oversight when talking about these residential placements. Again, as you know, a residential facility is the most restrictive place for a child, should be for a very limited period of time and a very specific purpose. So in some of the work the OCA has done over the last several months, almost a year now, in talking to the courts about what kind of information they are getting and whether they felt like they had enough information around specifically these residential placements. This builds out a much clearer structure for both the information the court is receiving from the department during that process, before a child is placed, during the time the child is placed, with really the goal to be that a child should not be languishing in a residential placement for any longer than absolutely necessary and is receiving the appropriate therapeutic interventions there. And again, as I'm sure you all remember from the testimony originally on this bill, it relates back to the Bledsoe incident that occurred in Tennessee when we found those two children at essentially what was a youth detention center, but should have been receiving therapeutic care. So that section of the bill, again, pulled over from HB 1573, having to do with the court's oversight with the effort really to get the children out of residential care as quickly as possible.
My voice doesn't carry. My name is Krista Morris. I'm the Director of Intergovernmental Affairs with DHHS. And basically, Lissa went through, I think, all of the major points of the amendment. I want to include the fact that we removed the word qualified from qualified residential treatment facility. That is basically just so that these facilities, it's a federal title. It has really nothing to do with certification. It's so that they can receive foster care funds if they want to apply for it. And then also there are changes being made to HB 1573 right now, in-house finance. And so in order to just let this bill move forward, we know that we acknowledge that there will be changes made in 1573, and we will try to catch everything back up once those changes are made and your bill, I don't know, crosses over or somewhere along the line.
Okay, are there any further questions? Are there any questions? Okay, seeing none, thank you both very much for coming forward and walking us through the amendment. So we have amendment number 1063S. Does any member of the committee have any questions on this? Okay, the motion is ought to pass. All in favor say aye.
Aye.
Any opposed? Okay, so there's a motion on the bill of ought to pass. Is there a motion for ought to pass as amended?
So moved.
Moved by Senator Whitley, seconded by me. Okay, is there any discussion on the bill as amended? Senator Whitley?
Yeah, I just want to reiterate the importance of this work and acknowledge the work that has been led by Senator Carson in the Oversight Commission on Children's Services. It's a very collaborative group. We meet, in fact, it's the most productive commission that I've ever been a part of. We think deeply about the challenges facing children and families, and we're very solutions oriented. And so I'm grateful for all the hard work. I know there's some significant policy changes in here, but to have everyone at the table come to an agreement for these changes, I'm very grateful.
Are there any further questions or comments? Okay. The motion is ought to pass as amended. Okay. All in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Okay, Senator Whitley moves consent. Is there a second? Second by Senator Gannon. Okay, is there any discussion on this consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Senator Whitley, would you like to?
Thank you.
Okay. Okay. Next, we have Senate Bill 423 that we're going to take up. We have an amendment. I have ought to pass. I'll make the motion of ought to pass. Is there a second?
Second.
Seconded by Senator Whitley. I have an amendment, which is amendment number 0715S, and I will make a motion of ought to pass on the amendment. Is there a second?
Second.
Seconded by Senator Whitley. Okay. One of the things that we heard consistently from the insurance agencies is they were very concerned about privacy. And so what this amendment does is it addresses their concerns about privacy and not making sure that this information just doesn't get splattered every place. So again, I think we have addressed that particular issue on the amendment. And then if we pass the amendment, I'll speak to the bill itself. Okay. Senator Gannon?
A question for you, if you'll take it.
Yeah, I see.
No, not those things. just in line one, where it says upon request by a claimant, you really haven't filed the suit yet. So does that make everyone a claimant without being a claimant? Anyone can ask this information of someone? You use the word claimant in line one, where
Right.
you haven't filed a legal claim. Is that the correct term to be using?
Yes, it is.
Okay.
Senator Abbas?
Yes, and I think the term claimant, when you file a claim against, with the insurance company, you submit it to the other driver's insurance, you would be, they would categorize you as a claimant. I think in that context, it's referring to, this is pre-suit. There's no lawsuit filed yet, so I think that's what.
Because if I remember correctly, we had testimony that if someone wanted to file a court case and they wanted to know what the policy limits were, they'd actually have to go to court in order to open that up. So that to me just seems burdensome. That I believe the testimony we had that no other New England state does this. And so we're just trying to make it easier for the person who's trying to file a claim.
Can I ask you one more question?
Sure.
Thanks. So you're asking me, before you file a suit, you're asking me for my insurance or my insurer for the insurance information. Do you have to give anything on your side? Is there a give and take like in a normal legal transaction? Is there reciprocity of information that you have, like you broke your leg using my ladder and you're suing me? Do you have to give me anything back, or is this just a one-way street?
Senator, I can't answer that question.
Okay.
It's really someone who is making a claim for whatever reason that they've been injured. And they want either their medical bills addressed or for some other reason. They just want to get the information. And at that point, it's up to them to decide whether or not they want to file suit or they want to negotiate and mediate with an insurance company. That is going to be determined by an attorney. Senator Whitley and then Senator Gannon.
So are you referring to the issue of mutual disclosures? But that's only if a suit has been filed. But what
Correct.
this bill is addressing is prior to suit. So basically, the passage of this bill will mean that you don't have to file a lawsuit to get this information if it
Correct.
belongs to you, essentially.
So my fear is, which is more with the bill than this amendment, is that as a lawyer, I would sue for more money. If I'm going fishing, I find out you have this big policy, I'm gonna sue you for the policy limit. I might have been only going for $250. I see you get this big amount of money, I'm going for the gold. So to me, you're encouraging litigation.
Okay.
But-
Senator Abbas?
I wish my colleague from District 23 was correct, because where I practice the majority of the law, that you're allowed to get this, and I always smile when I see a nice large policy limit, but my experience is you can fish all you want, it's not gonna matter. So I can say that with confidence, but what this will do, just so at least in my practice, is sometimes there's a healthcare lien, and if the person if the person at fault doesn't have significant assets, and let's say their coverage is at 20,000 max per person, you can use that information to sometimes negotiate a reduction in the healthcare lien, and that doesn't actually change what I would get paid. It does change what that person would get. So you kind of having an understanding where all the funds are, where they'll be, often helps cases get resolved without the need of litigation. So for insurance company purposes, they may not have to pay most of them have outside counsel that they kind of farm these out to. They won't have to pay that. But if I look at a case and I kind of evaluate it as around 30 to 35 and 20 is what they have, sometimes they can have that right away, and that might make more sense. It really depends on what the client wants to do, but I could never even advise them on that and make an informed process or have an informed conversation without knowing what the policy limit is in the first place. And the same thing with the lien holder. They're not going to want the medical company. They're not going to want to. They ask, well, what's the coverage? So that's kind of that information is needed. So I would have to file the suit to get it. This would save some time with the courts too, and even plaintiffs' attorneys make their job easier.
Okay, we have amendment number 0715S. Is there, and there's an ought to pass motion, Matthew? Am I correct? Okay. Is there any further discussion on the amendment? Okay, seeing none, all in favor say aye. Aye, opposed?
Nay.
Okay, 4-1. Okay, I made a motion of ought to pass on the underlying bill, which is Senate Bill 423. Is there a motion, since we've amended it? Senator Whitley moves ought to pass as amended, and I will second. Okay, is there any discussion on the bill itself, as amended?
Senator Carson.
Yes, Senator Chandler.
Thank you. So I voted for the amendment. I think the amendment improves things, and I will say that this is one of those bills, and this is a good thing, that sometimes there's a lot to consider, and probably even more so, the more I look at it, the wider and broader my perception is. So I am struggling a little bit with this, and I do think the amendment certainly improves the bill, but I'm not sure I'm prepared to vote for it. So I just wanted to.
Okay. That's fine. Any other comments? Senator Abbas?
One other thought, maybe not in every case, but if a lawyer were to advise a client to perhaps accept a settlement agreement without knowing the policy limit, that could be malpractice as well. So I don't even know how they're doing their job without knowing what the liability is. Especially, when I look at a civil case, I always look at, it's not just getting a piece of paper that says you recovered on behalf of a client, it's actually getting the money too. Without that, I mean, it's just, you don't accomplish much, right? So this needs, I think it puts clients claimants in a position where you can really tell them, this is the path that we can go. And going through the litigation process can be tough. And I think it's important for them to know in advance, it may not really be a bright light at the end of the tunnel. Even if liability is not contested, rear-ended at a red light, I mean, it's what it is. But if that person's policy is very low, I had one that's basically exactly what happened. The injuries exceeded the amount, but the person was on a fixed income. There was collectability. Knowing what the policy limit was, you were able to resolve that quickly. It also gets the person who missed a lot of work some recovery right away, at least sooner. So there are a lot of pros to this. I don't know what the cons are. I know there's worry about privacy concerns. I've never heard of someone going out of their way to disclose someone's policy coverage information. I mean, on your insurance card, in the proof of insurance, it says it right on there. But I've never heard of someone plastering that online, and even if they did, I'm not really sure I wouldn't like it if someone did that to me, but I wouldn't really, it was kind of, oh, well. I guess there's no consequence to that. It's just more inappropriate or rude. So,
Senator Gannon?
Just a quick question for you, because you practice in this line more than I do. Are you more apt to bring a suit if you know that someone's limit? So this is pre-suit here we're talking. We're talking prior to filing a case. You wouldn't, if you don't think if you find out earlier, you're more apt to go to court then when you find out that the person you might sue has a large number? Isn't this inviting more litigation? Which would hurt our business environment, hurt insurance companies, and then our premiums go up. So I'm just looking to help keep our premiums down.
as a plaintiff's attorney, your goal is to recover damages, and to do that, and you have to also weigh the litigation cost side of things. If you have to hire expert witnesses, they can make more than the lawyers have to. So there's a lot of benefits, perhaps, of sometimes less is more, in knowing what the recovery can be. Now, if it also depends what the damages are, and if there's challenges to liability, that's how you can. Sometimes the damages are lower, but it's because there's a liability issue. That's a knockout on a claim. So I think for this, I'm just saying I'm not sure what I would even do if I didn't know this. When I look at a file, the first thing I want to know is what's the insurance coverage. That's literally one of the things right in the intake form. I'm surprised this wasn't already the case, and I've been curious how the New Hampshire bar has been handling this the whole time.
Senator Whitley?
So what I hear Senator Abbas saying, and correct me if I'm wrong, is that, passage of this bill would perhaps encourage settlements? Is that what you're saying?
I think it will. because I think the plaintiff's counsels will be able to inform their clients better to make more informed decisions.
So meaning, we're encouraging settlements, which reduces litigation, which I think is a good thing. The other piece to it, and I'm curious is, you seem surprised as a plaintiff's attorney that this is even something that we're dealing with. Is it the case that other states just have already done this? Already require this?
It's not that they allow this, at least in other versions, but I'm just telling you on like the intake form that I go through, this is one of the first things that I want to know. Because again, it's not just what the liability is the ability to recover that liability. And part of that is do they have insurance coverage or not? And what's the degree of that? I mean, a person can have catastrophic injuries with a small policy. That's an unfortunate situation, but knowing that in advance, you can create reasonable expectations for the claimant. I just don't know how a lawyer is even going to be able to go about this without knowing that. You can't. You have to file suit at that point.
Okay. Okay, are there any further comments or questions? Seeing none, the motion is ought to pass as amended. All in favor say aye. Aye. Any opposed?
Nay.
Okay, I guess it's 4-1.
No.
No? Okay, it's 3-2. 3-2, okay. And Senator Abbas, do you want to take this out?
Yes, sure.
Okay.
So just to be clear, Shannon and.
Yep,
Yeah.
yep.
Senator Chandler, excuse me.
Okay, next we have Senate Bill 462, relative to removing the cap on damages for wrongful death, loss of consortium claims. I'm going to move ought to pass. Is there a second?
Second.
Seconded by Senator Whitley. We have amendment number, it's 1044S. And I would like to move ought to pass on amendment 1044S. Is there a second?
Second.
Seconded by Senator Whitley. Okay, we got quite a bit of pushback on this particular bill from a variety of different places that really felt strongly that we needed to keep the caps in place. So I listened, I heard, and we kept the caps in place. The amendment, that's exactly what the amendment does. But what it does do is it raises the amount of damages. This bill, this particular statute hasn't been raised in over 25 years. And I think that's wrong. It should have been raised right along. We don't live in the same world we lived in 25 years ago. And I think we all know that today's dollar doesn't buy a lot. Okay, and if somebody has been injured, they have lost a spouse through no fault of their own, that either the person was in an accident or something happened to them, it takes a while for that family to recover. Whether it's someone who is now going to be a single mom and has got to go back to work and now facing with a reduced income as well as expenses that are extremely high, childcare being one of them, or someone who's a widower that now has to hire someone to help him care for the children because he's working. Those are significant expenses today. So what I did, and it's on line 21, I went from $150,000 to $500,000. And on line 31, where we're talking about the decedent being a minor child, I raised it from $50,000 to $300,000. And that's pretty much what we do with this particular bill. Any comments? Senator Gannon and then Senator Abbas.
Thank you, Madam Chair. Any actual aerial analysis. So to me, coming up with an arbitrary number of 500,000 is a 330% increase.
Yep.
The cost of living would have been certainly well less than 300. So I find it arbitrary, the figure you picked there. The same with the 300,000 from the 50, 600% increase. Everyone tells me that these costs aren't going to affect anyone other than the business industry, the BIA and tons of the businesses say it's going to come from somewhere. And if I just use simple logic, if the insurance company is going to have to kick in a larger chunk of money, someone's going to have to pay for it. That's either going to be the businesses or it's going to be personal policies. It's going to come from somewhere, and somewhere the rates are going to go up. And I think part of my job here is to keep the costs down of everything. So I think the numbers are too high, and that should be examined. And again, we didn't do any analysis of whether or not this is even needed and what the real true costs will be. I feel I don't know what the costs will be.
Okay.
So that's me.
Okay, Senator Abbas?
Thank you, Madam Chair. Just if we went with inflation / cost of living, whatever you want to call it, you would, for the most part, just be doubling what it would be. So you would make it 300 and 100. That was just by the math that I did. I use Google, so if my math is wrong, so is Google. But anyway, I think going a little higher than that is appropriate, because I don't think we want to keep going back to this every 2 or 3 years. But I would, if anyone wanted to provide an analysis, I think much of this policy was just simply opposed, and we didn't really get any from the different interested parties that opposed this. Didn't really provide us a recommendation of what that should be, because I didn't receive that information. So if 300 and 500 is not the right number, and someone who's very knowledgeable on this subject wants to convince me otherwise, I would certainly listen, but I haven't heard that yet. I think increasing it is certainly appropriate given just the inflation alone. Now, would that make it 500? It's more than inflation, but I don't think it's egregious.
Senator Chandler?
Thank you, Madam Chair. Thank you for bringing forward this amendment. When we can, I always want to find a compromise. And I think that this is probably the best effort we can make toward finding a compromise and bringing two sides with very different goals together. So I like the amendment. I do agree with both of my colleagues, both Senator Abbas and Senator Gannon, that the numbers should be higher. I am not convinced entirely that these numbers are right, but I don't think we got direction in really what the numbers should be. So I do agree with Senator Gannon. I'd like to see additional analysis. I'm willing to vote yes on this to move this bill forward, but perhaps as the bill moves forward, further analysis can be made to determine if these are in fact the right numbers.
Senator Whitley?
Yeah, and I think we have consensus there, and so I would encourage, I did see the commissioner here at some point, that that the Department of Insurance does conduct an actuarial study. I know folks were looking for that, and so perhaps that could be done with haste before, as it goes to the House.
Thank you. There's a couple things that I would like to point out. We had testimony concerning the case Carson versus Maurer. The New Hampshire Supreme Court made clear that recovery of a limited portion of damages cannot be equivalent to the recovery of damages in full. New Hampshire law hasn't kept up with that principle. And I think that's something that we really need to take to heart. New Hampshire is the only New England state with a cap on damages. Maine raised on damages before 1 million. Maine raised their cap to $1 million during the 2023 legislative session. The federal court will not even apply the current New Hampshire law because it is not representative of justice. To me, that was very important testimony. And I'll tell you the reason why I chose 500,000 and 300,000. We know that hopefully this bill will pass the Senate and it's going to go over to the House and they will come up with their numbers, and it's really giving us a negotiating position. I would hate to set it at 300,000 and have them come back with a lesser number than 300,000. So we're just starting this whole process, but I think we need to realize that we just have not kept up. And this is something we do. I had actually discussed putting in a consumer price index, so it just is gonna keep up with what's going on in the economy, and that fell on deaf ears. So the legislature will be dealing with this issue again, and I hope that sincerely, that it's not gonna take another 25 years in order to raise these numbers. So are there any further comments or questions? Okay. We have a motion of ought to pass on Senate Bill, on amendment number 1044S. Is there any further comments? Okay, seeing none, all in favor say aye. Aye. Any opposed?
Nay.
Okay, is there, the underlying motion has been made of ought to pass. Is there an ought to pass as amended motion? Senator Whitley seconds. Is there any further discussion on the bill as amended? Okay, seeing none, all in favor say aye. Aye. Any opposed?
Nay.
Okay, one, okay, and I will take this one out. Okay. Next, we have Senate Bill 501, and we have amendment, well, I'm going to move on to pass on Senate Bill 501.
Second?
Seconded by Senator Gannon. Let's see, 501. Okay, all it does is this 501? Yep. It removes the last sentence, proof of previous vehicle operation in the foreign country or proof of completion of an approved driver education acceptable course. The reason why I removed that last sentence, which in the bill is on lines 26 and 27, is we have the next bill that seeks to do exactly that, which was a request of the Department of Transportation. So rather than pass two bills, we can just amend this bill and pass this bill. Okay. Is there any further discussion on Senate Bill 50, the amendment on Senate Bill 501, which is 1024S? Okay, seeing none? Oh,
Second.
I thought they did. I thought they did.
Second.
Maybe, okay, Senator Whitley seconds. Okay, is there any further discussion on amendment 1024S? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay.
Move on to pass as amended?
Okay, Senator Whitley moves ought to pass as amended, and it's been seconded by Senator Chandler. Is there any further discussion on Senate Bill 501 as amended? Okay, seeing none, all in favor say aye. Aye. As opposed?
I move consent?
Okay, so, okay, it's been moved and seconded for consent. Is there any discussion about the consent calendar motion? Okay, seeing none, all in favor say aye.
Hi.
Aye. Any opposed? Okay, Senator Chandler, would you like to do this one?
I will.
Okay, next we have Senate Bill 568, and I'd like to move ITL.
Second.
Seconded by Senator Gannon. This bill, we just spoke to 501 with the change. This bill tried to do the same thing. And again, what I did was I just combined the two of them together. Because we did that, this bill is not needed. So is there any further discussion on the ITL motion? Senator Abbas.
If we combine this bill with another bill, would it make sense to maybe not give it a negative recommendation since its policy is essentially kind of part of another one?
Well, Senator, if we gave it interim study, there's the idea that we're gonna look at it and study it. We don't need this. This bill is not needed. It's already, what this bill wanted to accomplish, we've already voted on in a different bill. That's all it does. Is there any further discussion on the ITL motion? Okay, seeing none, all in favor say aye. Aye. Any opposed?
I move consent.
Okay,
Second.
Senator Whitley moves consent, Senator Gannon seconds. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, so again, do you want to do this one? Okay. Okay, next, we have Senate Bill 569. Yeah, is that, yeah, 569. I move ITL. Is there a second? Seconded by Senator Gannon. I'm sure you want to say something.
I do.
Okay.
So this bill, just as a reminder, just simply provides the same subpoena powers to the AG to enforce their civil rights law, same subpoena powers as they do for other civil areas. So I'm not quite sure where the controversy was here. If there's additional concerns about it, I sort of am not clear about what they are. So perhaps if folks want to consider an interim study so we can keep working on the issue, but it is certainly warranting a conversation because we're really just adding the same subpoena powers that they have in other areas.
So are you telling me, Senator, that if we were to make this an interim study, you would support the interim
I
study?
think I could, yes.
Senator Abbas?
So it was brought to my attention during the hearing that apparently the Attorney General's office also has this similar authority when investigating consumer protection claims, which I don't, just because it exists in other areas, I'm not sure the other area of law is actually appropriate. Reading this without even having a lawsuit filed or any pending civil litigation, essentially the government would have the authority to essentially just conduct discovery, yet as the person that's being investigated, or you would be the, I guess, defendant in the civil case, you don't have that opportunity to do the reciprocal discovery. They can compel you to make statements under oath and in writing. They can even apparently demand you to surrender some of your property with this. I'm looking at this, and that can lead to the potential of criminal charges, depending on what they find, and they don't even have probable cause. So I just looked through. I understand it's a civil case, but if they were then find something incriminating, and they're going to say, well, we recovered it other ways. So I have some concerns about the current. So when I say study it, I would be studying how to fix the consumer protection laws that allow this to happen, because I just find it to be compelled to give a written statement or a recorded statement and to turn over your computers and all that stuff when you can't. I mean, I guess you have to go into court and try to quash it. You might not even be aware of the subject matter of the investigation. So this is to me, although well intended, this was a concerning policy to expand it to civil rights. This can be also misused. I mean, I haven't ever heard of any examples of the consumer protection laws being misused by the Attorney General's office, to their credit. But at the same time, I just looking at this on paper, it is ripe for abuse. At least it can be. So I would be concerned about this policy going forward.
So Senator, if we were to change the motion from ITL to interim study, could you support that?
You have to convince me.
Okay.
Well, and what I would say is that you clearly haven't made up your mind, that there's just questions, which says like an ITL, clearly you're raising issues that do require further conversation. So I guess you were arguing for the interim study in your comments.
But I think if I can respond, what I would say is this policy to me, considering how some of the concerns I have, I am more confident giving this an absolute negative recommendation to kind of put a stamp on that. The studying type of thing and the research and the consumer protection laws, we can do that separately. But this policy just, again, mandating such disclosures, I think is, when there's no case filed, and it puts the government really in a superior position to when weighed against the civilian. So I'm not gonna, when I say give that a negative recommendation, I'm confident doing that.
The only thing, may I?
Yeah.
The only thing I would add is that it is bizarre that there's unequal authority, depending on the area of civil rights law or the area of civil law. So like, it is a bizarre set of circumstances that they do have subpoena power for consumer protection, but don't have subpoena power for civil rights enforcement. So that is a very interesting policy statement that I think, would warrant some additional thought, but, we can hash it out on the floor too.
And what I'm saying is they shouldn't have it for the consumer protection.
No, I understand
And
what you're saying.
I'm more inclined, if anything, which it crossed my mind, to amend this, to repeal that is what I'm more inclined to do. So I think part of me wants to look into, do more investigation to how that's being used by the Attorney General's office and how it has been used since it's become law.
Okay. So we have a prevailing motion of inexpedient to legislate. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Opposed?
No,
Okay, 3-2. Senator Abbas, you're gonna take this one out.
No problem.
I figured you guys were gonna argue it out on the floor and we'll be bystanders.
there you go.
Okay, next we have Senate Bill 573 relative to parental consent for medical care.
Can I request just a 5-minute recess, if I may?
Sure.
Okay.
Okay, the committee will be in recess for 5 minutes. Yeah.
Case where the client was investigated by consumer protection.
Yeah, no, it's okay. Shannon, you want to talk for 5 seconds?
Oh, that's. Approve that, approve that.
Oh,
It's like the doom and gloom. Of course I am. And it's like, you know, it's about, it's about when you know, you know, it's not about, you know, I can't believe that they were geez, you know, somebody's. If you're in a pantry, you get in and it's in the. Again. We're gonna come out of recess. We were discussing Senate Bill 573. Matthew, I think we have an ought to pass motion? No, okay. So I'd like to move ought to pass on Senate Bill 573. Is there a second? Seconded by Senator Gannon. We also have an amendment, which is number 1069S. I'd like to move ought to pass on this amendment and then speak to it.
Second.
Second by Senator Whitley. When we had testimony on this bill, we know that there are all these different issues concerning parental consent that they're all in different parts of statutes. And it would be a fairly heavy lift to bring them all together. So what I did was I turned this into a study committee. And as you can see, we have to review current New Hampshire health care consent laws, including circumstances where parental consent is not required by law, review confidentiality laws and identify what protections exist for healthcare information for minors in New Hampshire, solicit testimony, and assess whether any areas of New Hampshire, healthcare in New Hampshire, are not currently covered under existing parental consent laws and do not currently fall under existing New Hampshire or federal exemptions to parental consent for medical care. So it is a fairly heavy lift. But I do have two members of the Senate that will, hopefully if this passes, will be on this committee. Matthew, I believe we need to get a committee amendment with all that language and included on line 12, after where it says President of the Senate, comma, including one member from the majority and one from the minority. So that would be the new committee amendment. Is there a motion on the new committee amendment?
So moved.
Moved by Senator Whitley. I will Senator Gannon seconds. Is there any discussion on the new committee amendment? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, we had the underlying motion of ought to pass. Is there a motion of ought to pass as amended?
So moved.
Moved by Senator Whitley, seconded by Senator Gannon. Is there any further discussion on the ought to pass as amended motion? Okay, seeing none, all in favor say aye. Aye. Opposed?
Remove consent?
Okay, Senator Whitley moves consent. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Opposed? Okay. Senator Gannon, do you want to bring this one up? Okay. Okay, and the last bill that we are going to do today is Senate Bill 576. I'd like to move ought to pass. Is there a second? Seconded by Senator Abbott. We have an amendment. It is number 1088S. And is there a motion on the amendment? Senator Abbott moves ought to pass. Is there a second? Seconded by Senator Gannon. Okay, Senator Abbott, would you like to speak to your amendment?
Sure. It essentially clarifies what the original bill was supposed to do. It's the executor of the estate or personal representative. They have to, it initially said they have to provide notice to the clerk, but the bill didn't really clarify what that notice would be. The official notice of death, that's the language, that language is already used in statute. They have to provide that to the clerk, basically within 30 days of their appointment. This is, I think, important because it really expedites the process, the kind of cleaning up some of the voter logs. If someone were to pass away in state, this is done relatively quickly, but if you had someone pass away out of state, but they were a New Hampshire resident, it's a much longer process. This would, in cases where there's an estate being administered and that appointment's made by the court, it would expedite that process. And I think that's a good thing. There's some of the criticism is that there's no real strict penalty if they don't do this, but in executive estate, they're acting in a fiduciary capacity, so I trust that they they have a lot of housekeeping things to do, and this is just another thing they have to do. And there's no damages per se if they didn't do that, but it would be hard for them to represent they did their duty correctly, which they would represent to the court that they did.
Okay, is there any further discussion? Senator Whitley?
So, I can't support this bill or the amendment. I mean, I think we heard from the Deputy Secretary of State, who is in charge of elections, that this bill was entirely unnecessary. She said, just like Senator Abbott said, in-state deaths are already reported past the supervisor of the checklist. I did pass the amendment by her to see if this addressed her concerns, and it did not. She said 30 days is just not very long. And the biggest problem with the amendment is with out-of-state executors. They would have no idea what New Hampshire law were. Like, and I just think of who these executors are. I recently had, someone in my own family pass away. My mom was the executor. My mom is not a lawyer. Is not entirely sophisticated about these issues. And I think we're putting unnecessary burdens on executors, particularly if there's an out-of-state executor. So I don't think this is necessary and can do some harm here. So I would have preferred an interim study.
Okay, is there any further discussion? Okay, we have a motion of ought to pass on amendment number 1088S. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay. There was the underlying motion of ought to pass on Senate Bill 576. Is there a vote?
Ought to pass as amended.
Okay, ought to pass as amended by Senator Abbott, seconded by Senator Gannon. Is there any further discussion on Senate Bill 576? Senator Chandler?
Thank you, Madam Chair. And I have to agree with my colleague that Senator Whitley, that this really does not I'm not sure what the problem that this is attempting to resolve is, first off. And secondly, I think we're putting the onus onto a party that who should not in any way be responsible for this. I really don't think that this is the responsibility of an executor. When each of us is alive, it is our duty to register to vote, to alert folks if we move perhaps, to change our registration when we move, of course. But it is not to put that then onto the person who's managing our estate after we have died does not seem at all reasonable. That is why we have elected officials and appointed officials who do manage our voting and election system, not so that an executor of an estate should have to bear this responsibility. I think it is the wrong solution to a problem which it isn't a way to resolve this problem. Thanks.
Thank you. Senator Abbott?
Thank you, Madam Chair. When it comes to the administration of an estate, this is, in my opinion, one of the easiest tasks they're going to have to perform is this. So if they're capable of moving around bank accounts and conveying deeds, and these are all legal things that they have to do, is transferring titles and dealing with beneficiaries who are claiming share rights to certain things, and there's a lot. Some estate things can get really, really contested. To me, this is just an obligation that all they're doing is providing the notice of death to the clerk to inform that the person has now passed away. It's expediting the process, because for the deaths out of state, there really is no process for the clerk to be notified. It only applies to deaths in the state. Now, I distinguish between death in state, out of state. I did not, but at the same time, I didn't think it was appropriate to make that distinction, because this expedites the process in state, but for out of state, there really is no process for that. And my father, for example, he passed away. He was in Mass General, and his name was on the voting poll a year later. So that's it. He's been passed away over a year. So I'm just explaining that this law would actually expedite that notification. And again, it's a relatively small burden considering some of the other obligations that executive would have.
Oh, you're all set. Senator Gannon?
Quick question for you, Senator Abbas. So if they screw up and they don't do this, are they going to be punished or harmed in any way?
During the public hearing, my colleague mentioned, if someone doesn't have a legal background, should they be punished? So we didn't actually put a penalty here.
So there's no
However,
penalty.
However, when they represent to the court that they administered all this is the estate, this is one of the things that they would have to, I presume, represent was performed. If it hasn't been performed, they need to do it. We obviously need to do it before they close out the estate, but we put a 30-day time period in there. Could we change that to 60 days? I suppose. But again, that's just again to streamline the process, is to actually get this moving. And the appointment is not normally done until when someone passes away. The appointment is usually done, sometimes a couple of weeks after, at the earliest. So it's not done
I'm all
instantaneously.
set. Thank you.
Okay. Yes, Senator Chandler?
Thank you. I guess one thing that I will mention for your consideration is that when any resident of New Hampshire is preparing a will and thinking about managing estates, there's so much that can be done ahead of time, right down to planning the funeral and in fact paying for the funeral and disposal and so on, burial, whatever. The resident can prepare in almost every way to make it very easy for the executor. This is something that the individual who will be eventually the deceased individual can in no way do ahead of time. So I think that that leaves me saying, why is it then the responsibility of another?
Senator Whitley?
Yeah, and I mean, if the purpose is to streamline, we already streamlined. It's already required. It's already happening. So there's no need to streamline because we already have a process in place. So now we're making an executor, my mother, who's already grieving terribly at the loss of her brother, adding something that someone's already going to do. I just think it's totally unreasonable.
Yes, Senator Abbas?
Well, what is the process then when someone were to pass away out of state? How exactly is the clerk notified that person has passed away?
Well, we heard from the Deputy Secretary of State that that's not an issue.
Well, in state, there's a process. I'm saying for out of state, what is the procedure? It's my understanding that there isn't one.
That's not the testimony that she provided. She provided that it does happen. It may take a week longer, but that was not a problem that she identified. And so I don't know why we're creating a solution to a problem that the Secretary of State hasn't even identified. She thinks it's going to make it harder for those out-of-state executors.
I don't recall the testimony being there. I think there's a procedure in state, but none for out of state.
Okay.
That's why I understood the testimony.
Okay, we have a motion of ought to pass as amended. Is there any further discussion on Senate Bill 576? Okay, seeing none, all in favor say aye. Aye. Opposed?
No.
Okay, Senator Abbas. Okay, it's gonna take that out. Okay, can I get a motion to come out of executive session? Moved by Senator Gannon, seconded by Senator Chandler. All in favor say aye.
Aye.
Any opposed? Okay, we are out of executive session. Before we move on to other places, just want to remind everyone, we're meeting Thursday morning. And just a couple of things. Senator Fenton had his bill, Senate Bill 593, we were supposed to hear. I'm going to open that up and immediately recess it because he is not going to be available that particular day, and we will hopefully schedule it next Tuesday. So I just want members of the public to know that if they were going to be coming here to testify, that we're not going to be taking testimony that day. And that's about it. We're down to, I think we've got 8 bills left out of, how many did we have? 68.
All right.
So we've done 60 bills. So I'd like to thank all of you for all your really hard work. our attorneys that work with us hand in hand, and we'll get through the last date, and then it's off to the races with the House bills.
All right.
So thank you all very much, and take care. Bye-bye.
So precise, Kate.
No, your wing is working. Your wing is working.
Yes,
No,
look at you.
the wing's gone. There's gotta be a song in there someplace. Yeah.